All right, today we're going to talk about U.S. Embassy delays husband's visa, so they sued in federal court. I-130 approved, but still no visa. Federal court action explained. Today is Monday, July 6th, 2025. Let's take a look at this case. So this case is, they filed this case because they filed an I-130, but the U.S. government is taking a very long time to make a decision on the I-130. So they filed a writ for mandamus. So let's look at the details of this writ for mandamus for delaying their I-130. So here are the two plaintiffs, the husband and wife, and they sued all these defendants in their official capacity. So we're just going to dive into the details of this. And again, with the writ for mandamus, you cannot ask the U.S. government to make a decision in your favor or against. All writ for mandamus is basically saying is that you're delaying my case. Now it's your time to do your job and actually make a decision. So that's what it is. You can't say, oh, I need the I-130, the decision in my favor, the visa in my favor, give me the visa, not give me the visa. Basically, it's saying just make a decision. That's what the writ for mandamus is. Okay, we're going to just dive into the details of this. So it's a civil action brought by the plaintiffs to compel defendants to adjudicate an immigrant visa based on the I-130 petition for alien relative to benefit her husband. So basically, the U.S. citizen filed the I-130 petition, which is a petition for alien relative to get a visa for her husband. And I'm just going to go into a little bit of details. They're saying the Mandamus Act is confers the district court. The court case is in district court, like we saw. It's in the District Court of Columbia. Basically, what it does is to compel an officer or an employee of the U.S. To perform the duty owed to the plaintiff. So basically it's saying, hey, do your job, make a decision on this. You cannot say which way they're going to decide, but it's saying that things are taking a long time. It's time for you to decide so that we sue the U.S. government, right? So moreover, they have jurisdiction pursuant to, we see in Administrative Procedure Act. Okay, so let's take a look at the parties. So the plaintiff is a U.S. citizen. So there's two plaintiffs, one the husband and wife. So one plaintiff is a U.S. citizen who filed an I-130 petition for her husband. So basically that's how it works. The U.S. citizen files the I-130 for the spouse. And it says it was approved in October 2023 by USCIS and subsequently was sent to NVC. So when we see that they list a lot of defendants, the defendants are listed in their official capacity. So here is the defendant. He's sued in the official capacity as a Secretary of State. Here's the other defendant sued in the official capacity as the Acting Assistant Secretary of State for Consular Affairs. Defendant sued in the official capacity at the U.S. Embassy in Germany. Another defendant also sued in the official capacity. And just a statement of facts. I mean, they're going to keep repeating this all the time. So basically, here's a plaintiff. It's a U.S. citizen, filed an I-130 petition for her husband. So that's how it works. Submitted to the NVC. It was documentally complete December 2023. Scheduled. There was an interview at the Consulate Post in Germany, February of 2024, and they said at the interview, we need additional information from you. Bring some additional information or send us some additional information, which they did. And whenever they asked about, regarding the visa, they only received boilerplate responses in this case. That is just basically going through administrative processing. They would not give any time frame as to the issuance of the visa. So basically, they were waiting in a year. So over a year, despite the passage of over a year, they were waiting for the visa. They want to be unified in the U.S. and live as husband and wife. So they're saying that they exhausted all the administrative remedies and there's nothing else they can do. So they subsequently submitted all the documentation that was required by the consulate, and it's been over a year, and the immigrant visa has not been issued. So what they're asking is that what they're saying is that the defendants have unreasonably delayed, so they're taking over a year to adjudicate the immigrant visa. And let's take a look at the prayer for relief. So basically, what a mandamus, writ for mandamus, is asking for is to compel the defendants to do their job. So basically, compel defendants to perform their duties to complete processing. So you can sue the U.S. government if you have an I-130 pending, N-400 for citizenship, and they're not making a decision. You can sue them. You cannot sue them to say, "Hey, you have to rule in my favor." That's not how it works. Basically, you're suing them because it's taking. You've seen some of the cases that are taking years and years and years, and you can actually sue the U.S. government to make a decision on for them to perform their duties. So basically, make a decision on the visa. So here saying compel the defendants to perform their duties and to award any type of attorney fees that they might have. All right, if you like this, give me a thumbs up, like, subscribe, and thank you for listening. Bye-bye.